and a very, very warm welcome to all of you. It is an absolute pleasure to have our inaugural Wills webinar, not quite in Wills Month, which was September, but it's close enough. So for those of you who don't know me, I'm Lauren Smith, and I am the Key Account Manager at STBB Claremont, and I am the Public Relations Officer for our Estates Department as well. It gives me pleasure to introduce to you our participants this morning. First up, we have Rivka Hoyi, who has already been chatting to everybody. Rivka is our Director and Conveyancer. There she is. And Rivka heads up our Deceased Estates Department. And so a warm welcome to Rivka, and thank you for her time this morning. We then have Lindsay Bakari, the lovely Lindsay. Hi, Lindsay. Lindsay is one of our attorneys, and she is an associate in our Estates Department, working very closely with Rivka, and again, one of our people this morning on our webinar. So lovely to have Lindsay. And then last but not least, we have Karen Avenatt. Karen is our attorney, notary, and conveyancer, and she's also an associate working with Rivka in the Estates Department. So a very warm welcome to Karen as well. And we would just like to invite you, as I say, to send through your chats. If we've got time at the end and you know, people want you to chat via the microphone, that's also fine. And we will kick off now with Rivka. Thank you very much for your time.
Thanks, Lauren. Okay. So the concern that we have is that we see so many people's wills that are unfortunately invalid, and you've been with your will for years in your safe, thinking that you've left a valid will, and in fact, and also unfortunately, you know, we have occasions seeing a valid will, but it's so vague and the wording is so ambiguous that you're actually leaving your heirs with more of a problem, because we end up, you can have, they can be to the master could interpret it very differently to what you intended when you drew up your will in the first place. So it's important for us to share these kind of tips with you and our experience, and I hope that afterwards you'll then whip out your will. Hopefully you do have a will somewhere, whip it out and have a look through it after some of the things that we've chatted about, and do get in touch if you need us to update your will. Our costs of drafting a will are quite small in comparison to what you're dealing with. I mean, you're dealing with so many big assets, and you're dealing with the well-being of your family, and so something like 1,500 Rand for a simple will, or 1,800 Rand for a joint will, and a little bit more if it's a complicated will. It's not very much if you think that it's something that you don't have to update very, very often. So let's get through some of the bits and pieces and tips that we want to draw to your attention. And so I think first off, we'll just have Karen up, and Karen is going to chat to you about actual signatures and the validity around signatures and witnesses as well. Thanks, Karen.
Hi, everyone. Good to meet you, and I'm so sorry for all of my technical difficulties and joining late. The first thing that I wanted to talk to you about is the signature of a will and how important it is. If a will is not signed correctly by the person making the will, it unfortunately does nullify the will, and it would mean that it wouldn't apply after the person's passing. And of course, by that stage, it's too late. So it's something that is extremely important. In terms of the Wills Act, the person making the will, the testator or the testatrix, sign the will on every single page. They also need to sign before two witnesses who should also sign adjacent to the testator or testatrix on every single page. Interestingly, it's not a requirement for a will to be dated, but it is good practice, and we would certainly recommend it, because it means that if you make another will at a later stage or multiple wills, we always know which is the most recent one and which wish would actually apply to that person who's making the will.
Thanks. And it's so important when you go back after this or this evening or this week, the weekend, and have a look at your will. Look at, the witnesses at the moment. Certainly over the past year, the Master's Office is asked to identify the names of the witnesses. So imagine you're sitting with a will that you drafted or signed, 15 years ago, and you can't remember who witnessed your will. And so it is very important to put down, don't write on your will ever, just maybe attach a post-it or, a page, and just jot down the names of those witnesses. And you can add in something in brackets. So you're not going to be there when your will does get read by the attorney or the nominated executor. So it's important for that person to know, okay, who was Joseph? And you can put in brackets, that was your colleague at the time or your accountant then, or whatever, just to identify to the master that the person is not related to, to you, and we'll run through those as well, because you really don't want your will to be invalid just because of who witnessed the will. And also just in terms of that kind of ambiguity, the master, looks at everything. Look at your wording also in your will, and we'll get through as it goes. And I see questions that have been asked. It's all about interpretation. Keep things as simple as possible, or make your life easier. Just get in touch with us at STBB and we'll just draft your will for you, because people use generic terms that they've read, at someone else's will, or they see something online and they use words. For example, you'll say, so-and-so's going to be allowed to live at my property. I leave my property to one child, but the other child is going to be allowed to live there forever, and will pay rates and taxes. What does that mean? That's a phrase someone used years ago. What are taxes? Be very specific. And if you say that someone's got to be living, for example, on your property, rent-free or free of pay rates, those expenses don't disappear. So those expenses are still there. So you've got to specify who's got to pay those expenses then. So if you leave your property to me, Dad, my sister gets on the property, who's for the fact that she's living there? So just be practical. Read your will back to yourself, or have someone else read it, or send it along to us, and think about the practicalities in what you're doing. Think about, is it practical to leave one house to 4 people? Are they going to get along? What if someone wants to sell and the other 3 don't agree to that? People have left movables to more than one person. You can't leave a car to, more than one person. Car ownership, there can only be one owner of a car. So don't leave your car to both your sons. Leave it to one and give the other one something else, or cash, or sell the car and, split the money between them. So you've got to think about the practicalities. And there are things that you want to leave and you actually can't. It might be illegal. It might not be allowed. We'll get to some other things. But for example, we're dealing with something now where someone wants to leave a farm to more than one person. You can't. Agricultural land in this country can't be co-owned by more than one person. Agricultural land, well, it's owned agricultural, it can't be subdivided. So you can't leave a farm, for example, to my wife and children. That farm, if they are keeping it, for example, that would have to be held in a trust or a company. So many things that you think you want to leave in your will that you might not be able to. And one of the very, very important points that we're going to chat about now is the executor. And Lindsay's going to chat to us about it, because that creates all sorts of problems for us. And my top tip is just nominate STBB as your executor. Finish, clear, done, dusted. Thanks, Lindsay.
Okay, hi everyone. So when it comes to nominating your executor, it's not just, deciding to nominate your friend and that's that. There are really, really important things to think about. Firstly, when you nominate an executor in your will, you have to make sure that the will specifies that they don't have to furnish security to the Master of the High Court. If your will doesn't say that, and your nominated executor is not, say, your spouse or your children, then they will have to apply for a bond of security from a financial institution, and it's almost impossible for them to obtain such a bond. So ultimately, then you would need to get a professional person like an attorney or an accountant or STBB to be your nominated executor and to obtain that bond of security. And that bond of security will have an annual premium. And at the moment, I believe it's 0.5% of your gross assets every year. And that premium is payable by your estate. So it's just an added cost, which you could absolutely avoid having to pay if your executor is nominated correctly. So what we always recommend is an attorney or a professional be appointed as the executor, because it's also an incredibly emotional time in someone's life when their loved one has passed away and they're now nominated as executor. They don't know what to do. And they ultimately, in any event, are going to have to approach an attorney if the estate is over 250,000 Rand. The master won't allow you as that layperson, even if you're nominated and even if you are exempted from having to furnish security, they won't allow you to actually administer the estate, and you will have to find an attorney, and that attorney will then act as your agent. So we do, STBB does assist in that way. But if you, for example, have nominated your wife or your husband as your executor, they are a layperson, or even your child, and they're over 18, they then will have to approach an attorney of their choice. Now, if you nominate STBB or whatever company, but preferably STBB, then you've made that decision. You now are in control, even though you've passed away, of who they will have to go and see to administer your estate. You may have a particular attorney that you trust. So, and it's a very long process, and it's a very complicated process. So you obviously do need to have someone that you trust to administer that estate. If you, for example, die without a will, then again, your spouse or your children can be nominated as executor, but again, they will have to approach an attorney if it's over 250,000 Rand. So your nomination of your executor is definitely something to think about. And if you want to allow your family to get on with the grieving process and to not have to worry about, what documents need to be completed, who do I need to go and speak to, I would suggest you nominate STBB as your executor, because then you take that hassle away from them, and we do it every single day, so we know exactly what to do. Rev, back to you.
Thanks, Lindsay. Cool. Okay, so there are quite a few questions coming in, and we're going to kickstart and go through some of those. One of the questions that came up was which STBB branch do you contact? And so you'd contact us at the Claremont office. So even if you're sitting in Somerset West, we can certainly have you sign your will at our Somerset West office, but you can consult with us certainly on Zoom, unless you popping by to the southern suburbs. But if you specifically want to consult in person at any of our branches, that's fine. But do contact us at estates@stbb.co.za. That's our department email, estates@stbb.co.za, and send through your queries, your will instruction, anything at all, and Wendy and I will pick that up. And before I hand over to Karen, so our costs are, so a simple will, as in it's not too detailed and complicated. Our will fees start at 1,500 Rand plus VAT. And if there's a joint will, if a couple pretty much leaves, their estates, their joint estate to each other, and in the alternative, both of them pass away, the couple's quite happy to leave their estates to exactly the same people, leave our children, our grandchildren. They have exactly the same terms. We then draw up a joint estate, and that costs about 1,800 plus that. And of course, it just gets, if it gets more complicated, your will could cost a little bit more. But so you're looking at that really has not, it's not too onerous if you think about how important it is to have a will, and it covers your, your very valuable assets. And a quick question on the tariff. So the executor's fee is 3.5% of the gross assets of the estate. And that is negotiable depending on the complexity of the estate. If the estate is not valued at more than 250,000 Rand, it's what's called in Section 18.3 estate. An executor doesn't get appointed. A master's representative is appointed, and we don't have to complete the entire administration of estates process. And so our fee to report to Section 18.3 estate and to attend to maybe some minor assistance there would be about 10,000 Rand plus VAT. Okay, so I'm going to hand over to Karen. There are a couple of questions that we had. So first thing is, how should a will deal with a separate living will, Karen?
Okay, so a living will is, as the question states, separate to your will. I always like to imagine it or tell people that a living will deals with when you're still alive, but a will deals with once you've passed away. So your living will set out guidelines for what should happen if you're in a state that you will not have a reasonable quality of life following whatever medical situation you're in. So for example, you're in a really bad car accident, you're in a coma afterwards, you don't want to be on life support for the rest of your life, you don't want your family to bear that burden, you want to direct somewhere while you're still capable of doing so, what should happen if you land up in that situation. So we would prepare two separate documents for you in that instance. One would be the will, which we would keep because we would obviously be helping and involved after you've passed away. The living will, we generally recommend that you hang on to, and it's good practice to keep it with a GP. It can possibly be signed in duplicate if you wish as well. And then you could keep a copy in your house, your children, your spouse, somebody knows where to find that document. So if the worst did happen and you wanted a do not resuscitate order in place or don't keep me on life support indefinitely, then that would be in place. Generally speaking, we don't recommend it good practice to keep that with the attorney because a lot of the time in a panic situation or in a very sudden situation, your loved ones might not know where to find that document, and it might not even cross their mind that the attorney who's holding your will might also have that. I also just wanted to tackle one of the other questions that we had on the forum while I'm chatting with you again. One of the questions was whether you must sign your will in full on each page or whether you can initial anywhere. So the answer to that is you must sign in full on every single page of your will, and that is absolutely imperative. If you initial a page, again, it can be deemed qualified and reject the will. So it's very important that you and your two witnesses sign every single page. I just wanted to add to that as well that your witnesses should be someone who's completely independent. So they can't be a person who's named in your will, a surviving spouse. It can't be the person who you've nominated as an executor. This is also why we generally recommend best practice to get STBB or attorney, someone legally qualified to prepare and sign the will for you, because it's so important that it's done correctly at the time. There are no second chances with this, and we know exactly how everything should be signed, and you could just rest easy afterwards. Avenatt, back to you.
Thanks, Karen. I've got a few questions that are quite similar, so I'm going to just run through a couple that are quite linked to other questions that we received yesterday. And so it's it's all property related. So one question that we had from Sue was, I've got a number of properties. So I'm leaving a property for my husband and children, and then another property that I want to sell. And the question is, are there transfer costs involved and transfer duty? And then another question from Esmeralda was, if I leave a property in my will to my husband, who pays the costs, my heir or would my estate? So I just want to quickly summarize those, and you'll get a recording of the webinar afterward. And if there are any questions that you have, you can just get in touch with us at estates@stbb.co.za. So with regards to inheritance, if you inherit property, transfer duty is not payable to SARS, and that's a huge whack and a huge saving. Okay, but being SARS, there are all sorts of other taxes that they end up being paid, because your property does form part of your estate, and we don't have a chance necessarily to chat about all the taxes that go with inheritance and with the administration of the estates, but we share with everybody we do and some notes on all the taxes and estate duties, so we can certainly share that with everybody afterward. But so in terms of costs, when you inherit, the point is that you are leaving an inheritance to someone free of encumbrances and free of any liabilities. So if you leave a property to it settles your liabilities, that would be a bond that's on the property, for example. Your bond gets settled and your bond cancelled, and those cancellation costs will be covered by your estate if your estate does have sufficient cash liquidity, as well as transfer costs to transfer the property to the heir. Of course, if your will is drafted such that you've only left assets and there isn't cash, then any cash shortfall would have to be paid in by the heir, who will then be inheriting that asset. So with rights come responsibility. So, anything that if you're inheriting and there's insufficient cash in your mom's estate, then you would be called upon together with other heirs pro rata to pay in the cash shortfall. And, we can always chat about that when you've got that scenario. And so, of course, there are some agents online as well. So if you are selling a property for a deceased estate, the estate pays the agent's commission, because the estate is the seller. So all the seller's liabilities are covered by the seller or by the estate. And so too with inheritance, you're transferring a property to that heir free of all encumbrances and liabilities, and so you would certainly be liable, your estate would be liable for those costs. And so do bear that in mind, and listen to and watch that little video clip that Lauren will send you, which has some costs and tips as well. And then that's with regards to the inheritance. And then the question was, there's also a family home that will be sold. So the home that will be sold, the purchaser will pay the transfer costs like one normally does when a purchaser buys the property, and the estate will cover, as I said, seller's expenses like agent's commission, bond cancellation costs, compliance certificate costs, but generally the purchaser will pick up those costs. And then also linked to property, let me just see. And so it's a little bit of saving if you in community as a little reward. There's a transfer called, it's a Section 45 endorsement. So if you co-own a property, which you would because you're married in community of property, so remember that you co-own assets even though your asset might be your name only. So there's the joint estate. So when you pass away, your will is only dealing with your 50% share of the joint estate. So if there's immovable property, for example, as administrators of the estate, we're only dealing with your 50% of the house. The other 50% is actually owned by your husband, even if the property is registered in your name only and after transfer of the property, your husband will automatically co-own that property, even if his name's not on title. So that, and we're just dealing with 50%. So we then attend to a Section 45 endorsement at the expense of the estate as well, to transfer that property into your surviving spouse's name. Okay. And before we get on to some of the other things that we wanted to, and I think maybe the next question would be about a usufruct or habitatio. So I think, Karen, if you want to cover that. And the question was, should my mom die and my brother gets a right to the house? Can you just explain that? But I'm leaving, so mom dies, she's leaving her property in her will to me, but my brother gets the right to live in the house. Okay.
Okay, so we get a lot of questions around usufructs and habitatios, specifically what they are and what they would actually entail, and often what the practicalities could be. It would generally depend on the family situation, and if we consulted with you to prepare a will, I'd probably ask you quite a little bit more information about the dynamics so that we can give you some specific situations and advice for your scenario. But in short, a habitatio is a right to live in a property, and that is simply the only right you have, to live in the property until the day that you die. While a usufruct, I like to remember it as use and fruits. So you can live in the property, you can also use it. So for instance, if it's a large property, you would have the option to rent a portion of it out, and then the fruits of that rental that came in would be yours as well if you have that usufructory right. If you do have a habitatio or a usufruct, then it's something that you would generally be well recommended to include in your will. It is possible to register it against a property separately. So you would have to allow for it in your will. You could actually also, before you pass away, register that habitatio or usufruct against the property. And when you did pass away, it would then be dealt with as part of your estate as well. As I said, though, it is something to consider very carefully, because obviously if you've got a situation where perhaps there's multiple siblings and there's a surviving parent in the house and they want to leave the property to one child, subject to the other child, for instance, having a habitatio, so a right to live there, that can cause a lot of conflict and issues. There might be various reasons for doing that. So it would definitely be something to be carefully about and that we could guide you on, but it is certainly possible. Back to you, Rivka.
Thanks so much. So next up, I'm just going to jump to a question that we had, and it's not on the chat, but we received it before. And so, Lindsay, if you could just explain to everyone about dealing with South African assets and foreign assets and how people will deal with that in their wills, or if they are South Africans who are living overseas and maybe they've got assets here and there, or not at all, but they just live over there, but their assets are in South Africa. So those different scenarios. Thanks.
Okay, so you've got what we normally recommend. If you've got assets in South Africa and anywhere else overseas, that you have a will in South Africa which applies only to your South African assets. And then, for example, say you've got assets in France, we would recommend that you approach a solicitor in France who knows the law, and they then assist you with a will for your French assets. The reason being is that, keeping with the France example, the law in France, we know South African law very well. We don't always know the ins and outs and the particulars of another type of law. So, for example, in France, if you had to, in your will in South Africa, make it a worldwide will and say, I leave everything to my best friend, French law would determine that actually, no, you can't do that. You have to leave a certain percentage of your estate to your wife. So that could create a lot of difficulty for your beneficiaries. So again, we always recommend you have a will in South Africa that deals with your South African assets and a will overseas that deals with those assets. It doesn't mean, though, that you have separate estates. you still have one worldwide estate, and we in South Africa would still have to take your overseas assets into account for estate duty purposes. So it wouldn't be included in as an asset in your estate, but it would be seen as a deemed asset for estate duty, because obviously SARS want as much money as they can make. So there are exemptions. So for example, you are a complete non-resident of South Africa and you only own this immovable property in Cape Town. Then if we can prove that you're not a resident of South Africa, then your overseas assets would not be taken into account for estate duty purposes. If you are a resident of South Africa, but you inherited overseas assets from your parents who have never been resident in South Africa, you can also then deduct the value of those assets for estate duty purposes. So there are a lot of ins and outs that you need to know when making your will and when you own overseas assets as well. So it's always a good idea to come and speak to an attorney, someone in STBB, one of the three of us, because we do know what we're doing and we know what we're talking about. And it's not as simple as saying, I leave this house in France to this person, this house in Germany to that person. You've got to know exactly the consequences of those bequests. Okay, Ref, back to you.
Thanks, Lindsay. And on that, it's so important what we deal with every single day, not even, foreign is assets, just our regular, you and I, we've got our assets here in South Africa, very simple will. And then what do? Your will, your wording of will is important, because you need to understand what it means when you leave your assets to your descendants or heirs, through what some of that wording means, and you would have seen it maybe in your own will and just glossed over it, not unnecessarily what some of that wording means. But it's so important for us that your wishes as the testator are actually carried through. And it's so unfortunate when what you intend for is not actually reflected in the wording that's used, in the way is drawn up, and that is said by the master, because then that we're bound to that wording and that interpretation, and that's what we have to implement and administer. So for example, if in my dad's will, if it says that he leaves his estate to, I leave my estate to my 3 children, boom, that's it. He hasn't put down alternative beneficiaries. His will is very simple. It just says that when I die, I leave my entire estate to my 3 children. What does that mean? That means that if I predecease, so by the time my dad dies, he doesn't update his will, and he's left his estate to my sisters and I. But I have predeceased him. So I died, 6 months before my dad, and he never updated his will, forgot about it, I'll get around to it, never did, passes away, and his will still mentions me. It says that it goes to the 3 of us. And so it's silent as to failing beneficiaries. My dad might not have intended that my heirs would inherit, but that's what happens in terms of the law. So I've fallen away, I've predeceased, but my inheritance still goes to children. Dad have intended that. So my dad might have meant that he might not have wanted his house to be co-owned now by my 2 sisters and my children. Or, they might not all get along. They might not even know each other. So, well, and when you send us your ideas and your thoughts of who you want to leave things to, put down, in the event of this person predeceasing, or if someone passes away within 30 days, of my death, that person's share should then go to my surviving children or someone else. Or you might intend that, I do want my late daughter's children to inherit, or, whatever. So it's very, very important that those things get put in. And you might have seen in your own will, there might be a Latin clause per stirpes. And that means that if my dad had left, let's say my dad's will says, I leave my entire estate to my 3 daughters. And failing any of them, for example, or it says all their descendants per stirpes, that means that if my dad passes away and let's say, 2 months after my dad dies, one of my sisters and I die in a car accident. So it then means that, my share, that share gets divided between my children, and the other 50% gets divided between my other sister's children. And so it's very important that intention is quite explicit as far as possible. And, that's such a common one where people didn't necessarily intend that that's the ultimate, that's actually what's going to end up happening, is that we end up co-owning something with, my nieces and nephews. And before you know it, 15 people are co-owning one house where it wasn't the intention. And so we had a question from Sue along that line. And Sue says, my mom's home is on her name. Dad passed away 14 years ago. We are 4 remaining children. My brother passed away last year. So dad passed away, and then his son passed away, and now mom is still alive. And she's asking, will a share, when my mom dies, will my late brother's children automatically inherit or not? And that's completely dependent, Sue, on what that will states. So you're welcome to send a copy of that will to us so that we can have a look at it. And it all depends on the wording. And so, as Karen said earlier, it's, once a person passes away, that's what we're left with, people. We're left with a valid will, and that's all that I'm armed with. I'm armed with a will, and that's the document that I need to respect and implement and make good on. And so it's so difficult if you know that was not mom's intention. Mom always said to me, and and then it becomes a family dispute, and we deal with very unhappy people, unfortunately, every single week, because you're so frustrated because mom never intended that. And so let's rather see what your intentions are. How can they be misinterpreted in the will, and how can we simplify that will and keep things as easy as possible? And then I just want to jump on to a very, very important topic, so close to my heart, of course, as a mom, and that's your minor children. And Karen's going to jump into what you need to keep in mind when you're drafting a will and you've got your minor children. So of course, as parents, you'll need to update your will as they reach different milestones. And over to you, Karen.
Thanks, Red. So we're sticking with what Revka is talking about, very importantly, intention. And I would just like to add to that many times when I consult with my client, they come and they tell me that this is what they think they want in their will, or what they would like to happen after they pass away, and I start asking them questions, often they will respond to me that they never thought that they had to even think about that. And I always like to say to them, if you're sitting with me and you're thinking about things that never crossed your mind, it means you're doing your will correctly, and we're getting to the crux of exactly what we need to address and making sure that absolutely every imaginable situation can be covered. So we'll, of course, be able to help you with that as well. And I would love to make you think about things that you hadn't need to think about. Just touching on minor children. So many times people come, and one of the main reasons they want to make a will is because they have minor children who are dependent on them, or they have major children who are not dependent on them, and they'd like to make sure that their children are taken care of and everything has been looked after the way that they would want for the future. So if you're dealing with an estate where you have minor children involved, one of the very important things to consider is who you would like to be the guardian of those children. If you pass away, and obviously if we're dealing with a husband and wife, then who would be the guardian of those children if they both passed away? So that would be one of the first questions that I would ask you if you came and chatted with me about your minor children. We again always encourage that you have an alternative. None of us ever know what the future will hold. So if you want to elect someone, it's always good to have a backup as well in case that person, for whatever reason, is not able to take up appointment. It could be that they predeceased you, or they're just not equipped to do it. There can be many things that happen. So we always recommend having at least 2 guardians named in a will. And the other thing that is very important is whether you want your children's inheritance to vest in a trust until they reach a certain age. So it would often depend on the age of the children when we were making the will. If they were, for instance, already 16, 17, so quite well on getting on in life, what does the estate consist of? And do you feel that it would be important for them to wait to receive that? So perhaps until they're 21 or 25, then we could certainly put a testamentary trust in place. Obviously, if you're dealing with minor children or infants, so very young children who may inherit when you pass away, and they could still be very young, then we would certainly recommend that you put in place a testamentary trust. So there's many things that people think about testamentary trusts, and they're often very concerned, and they're very worried that if they put a testamentary trust in place, it could have other ramifications. It could be costly. Is it actually necessary? Will it overcomplicate matters? So I believe, and I'm sure my colleagues would agree with me, that a testamentary trust is in fact very important for children who will be inheriting if they're not yet 18 years old, or perhaps even 21 or 25. In your will, you have the power to create a testamentary trust. So that's a trust created through your will for your children's inheritance to vest in that trust until they turn a specific age. So there is no age that's required in law that the trust must cease at. So you could select 18, 21, or 25. Those are generally the most popular ages that people would have a trust until. It is also possible to have a trust until the child is 21 or even 30. I've had someone once before who asked for a trust to 45, which I thought was a bit excessive, and we chatted about that a bit. Behind these as well. So often if you go back to the crux of why you're asking that, you can come up with a different solution. We would recommend that a trust be administered by a professional body, so someone like STBB, and we would obviously be able to prepare everything that needed to be prepared. So a trust does come with responsibility. There's obviously money that you're holding on behalf of someone else in your capacity as a trustee. And all of that is overseen by the Master of the High Court as well. We have to submit annual statements, so everything is 100% above board, and the Master obviously makes sure that everything is going the way that it should be. Another thing to keep in mind when you're dealing with the trust is just careful about who you want to appoint as a trustee. So again, back to always keep a professional body is my recommendation. It can cause conflict in families if, for instance, you have a surviving sibling looking after nieces or nephews who they perhaps didn't have a relationship with before, or they don't see eye to eye on how children should be educated or brought up. So it can create a lot of complications.
Karen. Okay, there's some more questions, and quite a bit of it is about the process and property, and so I just want to answer those so that we don't neglect anybody. And I know somebody asked about okay, so if I am from Debbie, if I'm married in community or property, will my assets be frozen immediately when my husband or I pass away? So in terms of understanding the process, once someone's estate is reported, or so your husband passes away, you're married in community or property, your life still carries on, your debts are still accumulating interest, your bond still needs to be paid, your rates still need to be paid, your credit card. So all of those debts and the interest, so number one, interest doesn't get frozen. That's often a question that I get asked from people, that won't my debt suddenly just, won't someone freeze the interest payment or my bond? Unfortunately not. The the wheels still keep ticking on debt. And so my advice really is look at what you each have as a couple in terms of bank accounts, shared expenses. Make sure that that's being used for debit orders, that there are funds in that account. Your bank accounts don't get frozen. Banks, so your bank account will open when you pass away. If someone comes to us, and people don't always come to us immediately, it really depends on how soon they, what they're dealing with in terms of their grief, how soon they accumulate all the documents that we ask them to accumulate. And we'll send all of those little checklists along to you as well, so that you know what we're talking about. So once we've collated all the documents that we need to report an estate, and that gets reported to the master's office, with any luck, we'll get letters of executorship, within 4, 5, 6 weeks, longer during COVID and lockdown. And so, but that's pretty much what we aim for, is to get letters of executorship within a month. Executorship. If we are the executors, or if you're the executor, maybe a surviving spouse, and you've given us power of attorney to step into your shoes as executor and agent, we then write to the bank, and then we contact the bank and ask them to pretty much close the your late husband's bank account, and we would have opened a deceased estate bank account, and funds get transferred into the account. Of course, we behind the scenes we're sorting out debit orders, and for some reason certain accounts might open, and that's based on the estate. But so it's very important, especially during that month while we're waiting for letters of executorship to be issued, that you understand that the debts still carry on. Well, they carry on after anyway, but then by that time we're dealing with it when we're dealing with the estate late account. So while the deceased's bank account is still open and active, debit orders are still going off, so there need to be funds in there. So if funds were supposed to be transferred by the deceased, if you've got the funds, then of course make sure that there's sufficient cash in those accounts so that the debit orders and everything still ticks along and interest doesn't accrue. I mean, if financially you're not able to do that at all, it's one of those things, debit orders are going to bounce, and, a bond installment has to go off. If you really have your cash strapped, cash is tied up in life insurance policies that will pay out, hopefully within a month or so, or sometimes even a few days. But until then, if you do get to that point where there isn't sufficient funds to cover, debit orders and things, we'll certainly pick up those pieces afterward and write to the relevant creditors and let them know that we're dealing with the estate, and they'll then send us a balance due. And as there's cash, if you're the survivor, I always say be practical. It's always about being practical and try and limit the expenses that you're going to deal with. You're the heir anyway, so start covering those expenses, because you're waiting for inheritance to settle those anyway. If you can avoid some of that interest. If, for example, it's your husband's passed away, and all the debit orders come off his account, and you're the surviving spouse, but you've also got children, and you and your children are going to be inheriting. You might not even be an heir. You might be the parent, and you're able to settle that for the family or pay that month's debit orders. Then so be it, and then you just send that proof along to us, and we put you down as a creditor of the estate so that you could be reimbursed accordingly. I mean, there are certainly people who just waive that, no, I'm not going to be putting myself down as a creditor. But there's no harm and there's no shame, nothing wrong at all with submitting all of that to the attorneys or the executor to put in your claim as a creditor of the estate, because you assisted by settling all of that. So many practicalities you need to keep in mind. So think about what your day-to-day life is like. As Karen said, your living will, make sure it's with your surviving spouse or your GP, your will itself. I mean, there are so many, we might be holding wills of people that have passed away and the family never even knew that they had a will with STBB, you know. So I think certainly even if you don't want people to know what the contents of your will are, certainly let people know that you have a will in safekeeping at STBB or wherever it is. And there's also a nice STBB we've got where I certainly want my husband to at least know what my password is to open my iPad and, you know, to get onto certain things, because you have got so much that's running on passwords, and it's very traumatic when someone access your life, you know, because everything's electronic at the moment. So those little practicalities about at least letting someone know where your passwords are, and we'll send that along to you as well. It's got absolutely, and it's quite nice also. Clients who passed away, unfortunately during COVID, it was COVID related, and it was an elderly couple, and they both passed away within 10 days of each other. And thankfully I had both of their wills in safekeeping, and attached to their will they had each given me a summary of all their bank account numbers, you know, all the companies that they had, their policies with their couple of things had changed over the years, but it's fine. I mean, I had a detailed 2-pager on each of these people, and their children were so traumatized, I mean, and sad. They had just lost both their parents within 10 days of each other, and their parents didn't live with their kids, and thankfully I had more information than any of their kids had, so it was a starting point. I knew that even if the account numbers had maybe changed, I knew that they were with that bank. I knew that they had car insurance with that company. So 90% of the information that they gave me was still valid. It was just the 10% that they had maybe updated and changed things here and there. But it really helped that family. So do think about all of those practicalities, and then on to, sorry, you know how I chat, and then on to a couple of questions that you would have missed. Okay, when there are minors in your estate, what would the wording be? Well, probably to be left to them, and if money is left to them, what age are they entitled to the money? So I think Karen covered most of that in terms of you know, dealing with minor children. And so of course the age of majority is 18, and it's so important, as Karen said, to just cover all bases with regards to minors, because we've got something called the Guardians Fund. And so if you pass away without a will, or if your will is silent as to what minor office has an arm called the Guardians Fund, and minor is under the age of 18, their inheritance goes into the Guardians Fund, and you have to apply for funds to be released. So for example, I've got a client who passed away. She had breast cancer and she was really young, and she died without a will, unfortunately, and she left a 7-year-old son, and her husband's still alive, but it doesn't matter. Her you know, his inheritance, this little boy's inheritance, is now going to have to be paid into the Guardians Fund. And as and when school fees are needed to be paid for next year, we'll need to get a statement of the school fees from the school and submit that to the Guardians Fund. And it's a palaver, and it's admin, and dealing with a government department. The money's safe. It's not like, you know, it disappears, but it's just another thing and some more admin. Whereas if she had a will and she had potentially a trust, you know, or she left it with a natural guardian, then we could have at least avoided the Guardians Fund. But so we would deal with the Guardians Fund if there isn't provision made. And then with regards to questions about property, so someone was asking, when in the estate administration process do you transfer the property? And so unfortunately, the estate administration process can take really long, because we're dealing with the master's office, and you know, they've got huge volumes, and at the moment it's quite difficult in dealing with them, because they're only accessible on email, and of course you can imagine all the people emailing them, so they have quite a backlog that they're working through at the moment. So in terms of the estate administration process, part of the documents that you might have come across or heard about is the liquidation and distribution account. So that's a very detailed list of all the assets and liabilities in the estate, and that gets submitted to the master's office after quite a lengthy process in dealing with creditors, SARS, and so on. And once the master approves the liquidation distribution account, we advertise it. That's the second advert that gets placed. And once that ad is placed and 21 after that ad is laid for inspection and all is well, no one's contested the L&D account, we are then able to proceed to distribute assets, and one of the things that we would need to do is to transfer the property to the heirs. If you're dealing with a sale of property, it's slightly in that you don't have to wait for the entire administration process to be complete before we can transfer to the heirs. So property can certainly be sold once the executor is appointed. The executor who steps into the shoes of the seller could sell the property on behalf of the estate, but all the heirs have to consent to the sale. So in the process, we have all the heirs consents to the sale, and that gets lodged at the master's office. And then again, it takes some time. So the master's going to be doing quite a bit of checking. And once we get the consent, the Section 42 consent by the master of the sale, we can then go ahead and register the transfer. So both happen at quite different stages in the process. A lot later when it's an inheritance transfer, but sooner the sale. Bear in mind that it sometimes think that as soon as he has been sold, transferred out of the estate, that on the day of registration of transfer, in the normal course of things, if the seller was alive, the seller would get paid out by us the proceeds of sale. After we settle his bond, we pay the agent's commission, his bits and pieces, his compliance certificate, and then we pay him the proceeds of sale. That doesn't happen with a sale of a property out of a deceased estate. The property is sold. The purchaser is now the owner. We receive the proceeds of sale and we pay if there was an agent involved, and we pay the compliance certificates. But then the funds go into that estate-led account, and it becomes part of the estate administration process to sort out SARS, and we can't do anything without getting clearance from SARS. SARS is always the huge unknown, and so yourselves out. Don't think that that debt also just disappears and dies. It does not. And so, so unfortunately, just keep that in mind, that heirs don't see the funds on date of transfer. They're going to have to then wait for the administration process for the L&D account, as I said, to be advertised, and down the line, people will get paid out. Hopefully there is sufficient money. Let's see if there are any other questions. And then Karen, just a question about the Testamentary Trust. So someone was asking about the costs of maintaining a trust.
Yes, sorry. Okay. So there's a fee that's charged. Again, everything that we do is tariffed, so we're only allowed to charge a maximum amount. There's a setup fee that's charged. In many instances, when we do testamentary trusts pursuant to an estate we're dealing with, we don't charge. In fact, for the most part, we wouldn't charge. It would just be something that we would do during the course of the estate administration. So we prepare everything, we send it off to the Master of the High Court, we create the trust, and then we maintain the file. If there is a charge for creation of the trust, it's generally quite nominal. It would be at most a couple of £1,000, but that really isn't something that generally we charge for unless there's a specific reason for it. The maintenance of the trust, so there are annual statements and income and expenditure accounts. There obviously needs to be a bank account. The trust fees are very nominal though, and we're only entitled to charge a percentage on the actual interest that's earned. So for instance, if you have a capital investment of R1 million and it's only making, say, a 6% income per year, you're making a very small amount of money, and then we can only charge what I believe is around about 6% of that at the moment. So in many instances, because of the size of the trust that we may be maintaining, the annual fees for many hours of work that we do would be even a few hundred rand. I've got one matter that I work on that we charge about 650 rand a year to maintain. We do believe in the work. So obviously, we'd like to know that you can trust us, and once you're gone, your affairs would be in order. So that really does come back to, it's something that is important to do, and I don't believe that any charges would negate the benefit of it, and it's generally something that would be sustainable. But do double check with any trust company if that's what you choose to do, as to what their specific fees would be, because there may be hidden charges that they've sneaked in here and there that we maintain trusts. Thanks, Ray.
Thank you, Karen. Let me just see if there's to Lindsay. That was all the questions on the chat.
You've
Just see if there's anything
this.
else that came through. Lindsay, yeah.
But I think one of the questions was, how much does STBB charge to keep a will? And I just want to explain that we obviously charge to draft the will, but we don't charge any fees to store your will, unlike the banks. So that is a free service we do offer, and the wills will be in our strong room, recorded, so that if and when you do pass away and your heirs notify us, the will be in our strong room, and we will send it directly to the master.
Thanks, Lindsay. Thanks for that reminder. And just on that, in safekeeping, we also keep, we don't charge clients to keep their title deeds. You know, we've got clients' antenuptial contracts. And then, of course, we've got our eVault. It's our electronic storage system. So if you've had the privilege of being one of our purchasers or sellers, you would have heard all about eVault. And for a once-off, I think it's 390 Rand, you then get an electronic STBB vault, and we upload all your FICA, your copy of your title deed, your offer to purchase. So even one day when you're doing your tax returns, you're doing capital gains tax calculation, or if you are planning to leave the country and you wish to repatriate funds and you need to prove, you know, that whole food chain of when you bought the property and what you paid for it and all of those things, it would be stored nicely in your eVault. And so too, you can now upload a copy of your will to your eVault documents as well. So it's quite handy. No other law firm offers that service. And I mean, it's 390 Rand, people, and then you've got this once-off personal little legal iCloud thing. So that's quite handy as well. And, you know, it's just a service where, you know, we've got such a good relationship with our clients. We're really not about charging for, you know, every single phone call, every email, storage of documents. It really is just an added service, so that we know that you've got all your documents under one roof. You've appointed us to attend to things, but it's so important that, you know, your family members or your loved ones actually know that we do hold your will, and that we are, you know, your nominated executors even. And so just the last couple of practical points. If you are like me and you've got maybe various versions of your will, just make sure that you, and your signed wills, various signed wills, make sure that you destroy your old one as you update one. So as soon as you've signed it, you know, and someone's sitting with a valid original, do destroy it. You know, if you pass away and someone starts sifting through your top drawer, you know, and they'll find a will, and then meanwhile we're sitting with an updated will, and I tell you, there's nothing like a bit of a family dispute, because someone's found a will that benefits them, and then we're sitting with another will, and then mom did, you know, some other will close to her, you know, her passing. And so Lindsay and Karen know what I'm talking about. It gets pretty hairy on our side, the things that we're dealing with. So help us to help you. Destroy your old wills. Let someone know where your your bits and pieces are in safekeeping. You know, I've got clients who are in South Africa, and all their children are overseas and their grandchildren, just them, just the two of them left here. So they've just introduced me on email so that at least there is know who we are, and that in South Africa, we're sitting with their will for their South African assets or even their worldwide stuff. So just those kind of practical tips. We were chatting about, you know, right in the beginning about signing wills and witnesses. And did you know when you're 16, you can start signing your will? So if you've got any 16-year-old out there who owns property or has some assets, here's a 16-year-old, you can start drawing up a will. You might have bought a property for your child when he was a minor, and now he's actually got an asset. So nothing wrong with that. And if you're signing your will and you're still not outside, you're still working from home, you prefer to be home, and we email your will to you, and you know your own family members can't witness your wills, there's nothing wrong with getting in your next door neighbor and her children, as long as your witness is 14 years old or older. You can even have a 14-year-old next door neighbor witness your will. But as I said, just make sure that you put their full names down so we can identify who that person is, because it does exclude that person from either acting as executor if the executor is nominated and had witnessed. And of course, unfortunately, if you know, I attended to a will for close friends of mine, and unfortunately, one of my friends had witnessed her late dad's will, and so her inheritance was unfortunately reduced. So that is quite unfortunate, and you know, and sad. And it is a sad time, and you still need to hear from me with all these practicalities and bad news. So right, I'm handing over to Lindsay and Karen if there's anything else they want to add before we say bye. And thank you, and I hope it was informative, and you'll get in touch with us on estates at stbb.co.za for any assistance whatsoever. And yeah, do get in touch, and thanks so much for listening today.
Thanks everyone for joining us, and I hope it was informative. There's nothing else from my side, but as Rev said, you are very welcome to contact us. You can email us, call us. We're very happy to help, and as Lindsay has rightly pointed out, we do know what we're doing, and there's a lot of things to consider. So please don't be shy. Get in touch if you need anything. Linz?
Yeah, thanks so much everyone for attending. There are so many things that go into will drafting, even things we may not have touched upon today. So please do get in touch if you want peace of mind and to know that your will has been done properly and professionally. But thank you so much for joining.
And everybody just remember, you don't even have to overthink it as to who your executor is. Very simply, just nominate STBB as your executors. We are 120 years old, so we'll probably be outliving any other person that you would have nominated as executor. And that's, you know, it's just painful when we do find out that your executor has passed away. So easy, just nominate us. We'll attend to everything. You know, we'll keep the family calm and updated, and we're very personal and hands-on and touchy-feely, and we update them all the time. We answer any question. They can be absolutely anywhere in the world. So do get in touch, and thanks so much for joining us today. Anything from your side, Lauren? All good?
I would just want to add that although we do have a national, can you hear me now? Can you hear me?
Oh, Lauren's breaking up. I can hear you now.
Okay. I would just like to add that we do have our national footprint of 11 offices countrywide, but our estates department is based at the Claremont branch, and we do take care of everybody's wills and all their estate planning requirements here at the Claremont branch. So if you are not close by, it's very easy to arrange a Zoom or a telephonic consultation, and everything else can then still play out the way it needs to. And other than that,
thanks, Lauren. Sorry, Corin, Sorry, Lauren, I missed one question. Someone asked about EVOLT, And you are welcome to contact us at
I did
estates@stbb.co.za if you don't have an don't have default, and we'll set one up for you. Sorry, Lauren.
No problem.
Good. Thanks, everybody. Have
Thanks,
an
everybody.
awesome Wednesday and a fabulous October, and looking forward to hearing from you. Bye.